Hello, everyone, and welcome back to the second episode of our new series where we want to discuss some of the basics of the PCT with all of you. I hope you were able to connect, and maybe you've already joined the first episode. If you haven't, it's been recorded, so you can always go back and look at that again on our PCT Resources website. As usual, I will give a bit of a presentation and will leave room at the end to allow you to ask some questions. And if you have questions as I go along, please type them into the Q&A, and I will monitor or try to monitor the Q&A and address your questions. If I don't get around to it during the presentation, I will do that as soon as we'll get to the Q&A part. So let me start sharing my slides. Okay, which worked when we practiced, and fortunately it's working also now when we're live. So what we want to discuss today are kind of the following topics. I want to go into some of the basics of the PCT, give you a good overview of the PCT procedure, and discuss a little where you need to file your PCT applications, which are the offices competent to receive your applications, and then depending on that choice, also which international searching authorities, or ISAs as we usually refer to them, would then be competent to do the search for you and issue what's called a search report and the written opinion. So in the first episode, we did discuss a little bit in more detail why you would want to file for patent protection to begin with. And then once you decided to actually go for patent protection, the question also then was discussed, do I file direct national applications, which would be what we call traditional foreign applications under the Paris Convention, that's the traditional system, or whether you would choose to use the PCT. And I think this slide was also part of our first episode, so I'm not going to spend too much time on that, but just to highlight again that this is like the fundamental question that you need to decide before starting, whether you will file multiple direct national applications at the end of 12 months, or instead file a PCT application before the expiration of 12 months. Now, let's assume we've opted for the PCT path, and we'll discuss this now in a little more detail. So an international application, basically, when you file an international application, by default, it will include the designation of all the member states or contracting states, as we usually call them, of the PCT. We currently have 158, so that's really quite a mouthful of countries you're including there. And of course, most applicants will not be interested in obtaining patent protection in all of those countries. So eventually you'll have to make a choice. But under the PCT, you can postpone that choice until 30 months from your initial filing date of your priority application. So most applicants start out with a national application, and then 30 months counted from that, you have time until you need to finally decide where and before which office you really would like to continue with obtaining patent protection. So as soon as you file the PCT application, you have the legal effect of basically filing 158 national applications or regional applications, if you want, in some cases. So this is quite powerful. But again, as I said, you're probably not likely to use this in 158 contracting states, but think of it more as buying an option that you could, if you wanted, continue in a particular country, but you don't necessarily have to. But you buy yourself the opportunity to think about it and further kind of research your invention, research the markets, and then eventually at 30 months, you'll take the decision where you would like to continue. Such a PCT application can be filed in a single language, filed with one office, and most commonly with your home office that is also working as a PCT receiving office. You only have to comply with one set of formalities, and then, as I said, it delays this famous decision where you really would like to continue for until 30 months from the priority date. So I'm not sure if I really explained priority date in all level of detail, but priority date is basically what we define as the filing date of an earlier application of which you claim priority in a PCT application. And I think the concept of claiming priority I already explained in the first episode. So it's the possibility really under the Paris Convention, which is incorporated into the PCT, to say, I file a national application and then I file a subsequent application, in this case a PCT, and I claim priority of that date of filing of the first application. And then my PCT application, or as a matter of fact, all other subsequent applications, will be treated for prior art purposes as if it had been filed already on the filing date of that national application. So if someone publishes something which affects maybe the novelty of your invention between the filing date of your initial application, your initial national application, let's say, and your PCT, that should not impact you negatively for the decision whether patents can be granted on your PCT application later on in the national phase, because you will be treated as if you had already filed it on the filing date of your initial national application. And I did mention the point about formality requirements relatively quickly, but it's actually a relatively important point because it really simplifies the procedure for applicants. And it's not only the same formalities during the international phase, but it's the same formalities that will also spill over into the national phase when you take your application to the designated or national offices to further process your application. They still need to apply the PCT formality requirements, and they cannot add new requirements or different requirements. So this is really, really an important safeguard for applicants and is intended, of course, to simplify the obtaining of patent protection in multiple countries. So this is the coverage of the PCT as we have it today. We are always proud to show that the PCT world looks nice and blue. And so all the blue countries here indicated on this world map are member states of the Patent Cooperation Treaty. Now, of course, we're perfectionists and we worry mostly about those areas which are not yet blue. You do see some of them in Latin America and South America, some in Africa, some more in the Middle Eastern region. So basically, there are still some countries which are not part of the PCT, and I'll come back to that in a moment. This is the list of our current 158 contracting states, and probably I can't really read this myself very easily on that slide, so I'm not expecting you to be able to, but this information, of course, is on our PCT website, so you can find all this information there. Uruguay is the latest member of our PCT family. For them, the PCT became operational on the 7th of January of this year, which means that an applicant from Uruguay, as of that date, can file a PCT application. And it means for foreign applicants, if you filed a PCT application on or after the 7th of January of this year, you will automatically have designated also Uruguay, which again bought you the option to decide at 30 months, I want to pursue my application in Uruguay. So you enter then the national phase in Uruguay. But it has to be international applications filed on or after the 7th of January. Otherwise, they're not yet covered by the PCT. And these are the states which are not yet party to the PCT. And we did stress up on top of that slide that these are recognized UN member states. And that is the reason why, for instance, the territory of Taiwan is not mentioned here, because Taiwan is not recognized by the United Nations as a state, and therefore they cannot join the PCT because they're simply not recognized as a state. Another country which is often mentioned by applicants around the world as to why they haven't joined the PCT is Argentina. So we are still very much hoping that they will eventually also join the PCT. Now, with Uruguay having recently joined, we were hoping that this might add a little bit of more incentive on Argentina to join, but it hasn't happened yet, so we're still waiting. Same for Venezuela and Pakistan, two other countries that, of course, a lot of applicants around the world would still like to see part of the PCT family. So when you file a patent application, and this is the same for the PCT as for a national application, when you file, you really would like to register this application on the day when you submit all your documents. And registering an application basically is what we refer to when we talk about obtaining an international filing date. So on the date of submission, if all goes well, you would like to get an international filing date. Now, why is that so important? Again, it goes back to the issue of claiming priority. Many applicants choose to wait until the end of the priority period, those 12 months from the initial filing of an application, to file the subsequent applications or the PCT application. So it's critically important that if you file at the very end of the priority period, that when you file, you do obtain this filing date, or in the case of a PCT, this international filing date. If you don't obtain the filing date and maybe you still need to correct certain things, then that will postpone the date that is given to you, and that might take you outside the priority period, which would mean that you lose the right potentially to claim priority of that earlier application, which in turn, of course, means that you might all of a sudden be exposed to intervening prior art, and that's really something that applicants around the world would like to avoid. So critically important to get this international filing date. And the requirements under the PCT to get an international filing date are arguably not all that high. So what you need to comply with is you need to show that you have an intention to file an international application. And if you use software that's available like ePCT to file your application, it's very clear what you're doing is filing an international application. You need to have a request in your application, which is essentially the request form, again, contained in filing software like ePCT, and that has the automatic effect of designating all contracting states. You need to name at least one applicant. So it's important to realize under the PCT, it's not possible to file a secret or anonymous application. You need to disclose who is at least one of the applicants. And you need to have something in your application that on the face of it looks like a description and looks like claims. This is, or a claim. This is really not a very high bar here. So receiving offices that receive your applications would really only look, is there a part that can be taken as a description? They don't actually read in detail through your description or try to understand your invention. And the same for the claims. If there's something that's named as claim number 1, claim number 2, and then there's a sentence next to it, without really looking at the contents and whether it's a good claim, they will take it on the face of it. It looks like a claim, and therefore you will get an international filing date. Now, I didn't mention on this slide that in principle, the articles also say that you need to have an applicant in your application who has the right to file with the receiving office that you're filing with, or that you have to file in a language accepted by the receiving office. Now, we don't include this anymore in the minimum requirements to get an international filing date because of a very important safeguard that was introduced in the 1990s, and it's called Rule 19.4. So if an applicant does not have the right to file with a particular receiving office, let's say you have a Canadian applicant and the Canadian applicant files with the USPTO as receiving office. On the face of it, USPTO would not be competent for a Canadian applicant. And before that safeguard was introduced, it actually meant you wouldn't get a filing date until you fixed that problem. But with Rule 19.4, the procedure now is that the receiving office that received the application needs to forward that application to the receiving office of the International Bureau. And the International Bureau can then accord an international filing date, and they will accord the date when the application was received, what we call with the non-competent receiving office. And the same for language. So I'm again picking on the example of the United States, but let's say you file an international application in Spanish with the USPTO. They only accept English applications. And in that case, also, they would take the case, send it to the International Bureau under Rule 19.4. We accept at the International Bureau all languages, so we could give that application an international filing date. So what this really means is that even if you don't pick the correct receiving office or you do not file in the right language, in the vast majority of cases, you still will get an international filing date. Maybe not from the initial receiving office, but then at least from the International Bureau. Now, the only situation where I have to make an exception to what I said is if you end up filing in the name of an applicant who's not a national or a resident of a PCT contracting state. So let me take the example of an applicant from Argentina. He or she wants to file a PCT application. If they were to file on their own a PCT application, they would not obtain an international filing date. As a matter of fact, such an application would not be considered an international application until an applicant was added who has the right to file a PCT application. A workaround in such cases, used in many instances, is that an applicant from Argentina has a co-applicant from a country that is where someone has a residence or nationality of a PCT contracting state. A few things not required to get an international filing date are you don't need to pay the fees up front. Now, that doesn't mean you get away with not paying fees, because offices will like to collect fees and remind you if you haven't done so eventually. But to get the filing date, you don't actually have to already have paid the fees. You don't even need an applicant's signature, which is maybe even less or is even more surprising. But a signature is a defect that can be healed subsequently. So if you furnish the missing signature afterwards, subject to an invitation from the receiving office, nothing will affect your international filing date. So you keep the date even if you didn't have a signature at the time of submission. Title of the invention, you should have a title of the invention and an abstract, which briefly explains what your invention is all about. But these two things can also be added later, so you don't need them absolutely to get a filing date. Drawings are also listed here as something that is not absolutely necessary to get a filing date. That's a little bit surprising maybe, because drawings are really one of the best ways to disclose your invention. Think of a mechanical case where drawings are really essential. So it's a bit surprising that they're mentioned here, but why are they mentioned here? Because there are some inventions that simply do not require a drawing. So think of a chemical case where you might have a lot of very complicated formula, but you might not have any drawings. So we could not, under the PCT, make drawings a requirement to get a filing date. Now, of course, that does not mean if you need drawings, you shouldn't include them at the time of filing, because if you don't include them and you really need them, then you potentially have a problem with a proper disclosure of your invention at the time of filing. And if you add drawings later, unless you're able to add them through incorporation by reference, which is another important safeguard in the PCT, then potentially you risk getting a later filing date, which would be the date when you submit the missing drawing. So applicants who file in technical fields where drawings are really essential to describe their inventions need to be very careful to include those drawings at the time of filing of their international application. What's also not absolutely needed is a translation into a language of search or publication. Now, those are more exceptional cases, but let's imagine, I mean, you probably all know that we have 10 publication languages in the PCT, and that searching authorities also do not work in all languages, but in specific languages. And so if you file an application in a language that is neither search or publication language, it's understandable that eventually you need to furnish a translation, but the PCT guarantees additional time for applicants in such cases to furnish an appropriate translation. Now, who can be an applicant of a PCT application? So applicants can either be natural persons, people like you and me. For instance, also the inventor, him or herself, can be both inventor and applicant, or, and that's probably more common in practice, a legal entity, a company. But we also, of course, have universities and research institutes, etc., etc. Before 2012, it was mandatory if you wanted to designate the US that you included your inventors as applicants. Now, this has changed after the law changes in the United States. So this is really no longer the case. And as a result, today, predominantly, we see applications with usually just a single applicant, which happens to be a corporate applicant, and then a listing of the inventors as inventors only. You could potentially have different applicants, multiple applicants, and you could have them for different designated states. That's more rare, but there are some companies who have done this traditionally. They have indicated several branches of their company and have then said, well, geographically, Latin America should be the states for which this applicant is designated, and Europe for that applicant. So that's theoretically possible, but in practice, we don't see this very often. But legally, it would be permissible. And I already mentioned this before, and it's still one of the critical mistakes one can make when filing a PCT application is to not include at least one applicant who is a national or a resident of a PCT contracting state. And it's important to really appreciate the or in this sentence. So if you are a national or Argentinian but living in Brazil, that's perfectly fine. You can file a PCT application. You comply with this requirement. But if you are from Argentina, Argentinian national living and residing in Argentina, then you do have an issue. And as I said before, you could get around this by adding a co-applicant who's maybe an applicant from Brazil, etc., etc. So where can you actually then file your PCT application? Well, applicants have at least two choices, and some other applicants have even three choices. So I think the most common choice for applicants is to turn to their national patent offices. There are an office that they're maybe already familiar with from filing their first national application, and they feel very comfortable also language-wise to communicate with them, and they know how to pay fees to that office, etc. So it's kind of a natural choice to turn to your national office. So they're putting on ahead as a PCT receiving office, act as a PCT receiving office when you submit an international application to them. The choice that everyone has is to file with the International Bureau of WIPO. So this is something that all applicants can choose. This didn't exist from the very beginning, but again, in the 1990s, when we introduced this Rule 19.4 that I talked about quite a bit before, we also started to act as a receiving office. And obviously, Rule 19.4 also only works because you can transmit these cases to our receiving office. So these two things really had to come in hand in hand. One of the things you need to, however, be careful about filing with us. Some national laws prescribe that you can only file applications outside your home country if you have passed a security clearance. Now, some countries say that's for all applications. Some say only if they relate to certain technologies, usually military type of technologies. But it's the applicant's responsibility to make sure that they comply with these requirements before filing with a foreign office. And the International Bureau in this regard would be considered a foreign office. So that's maybe one reason why you would want to be careful filing directly with the International Bureau if you know that you have made an invention in a particular country where there is a national law that requires you to first file with the national office. And the third option that's not available to everyone, but to many applicants around the world are regional offices. So for instance, in Europe, your choice is with your national office, the International Bureau, or with the EPO as a regional office that could also act as a PCT receiving office. Who's competent in your particular case? All of that is contained in the PCT Applicants Guide, which is a wonderful sort of information about the PCT in general, but also about details about where you can file, languages accepted by receiving offices, whether you need to be represented by an agent to do so. All of this is contained in the Applicant's Guide. So if you're not familiar yet with the Applicant's Guide, it's worth taking a look. It's an online publication that's available on our website and really is a great resource for anyone filing PCT applications. So when you consider choosing a receiving office, again, I guess it's often a question of convenience and what you're familiar with. Filing language will obviously play a large role. If you're interested in particular searching authorities, you might also think about which RO to file with, because the choice of ISAs is basically bound to the choice of which RO you are using. And that means that any RO or receiving office selects with which authorities they would like to work together with as international searching authorities. So let's say you file with the EPO, then you have to use the European Patent Office also as the international searching authority. Not all offices accept restoration of the priority right. That's a safeguard when you do actually miss the priority period. Some offices charge quite a considerable fee, so maybe selecting an office in a particular case where you missed the priority period and you would like to restore the priority right, maybe you want to choose an office that doesn't charge the largest of fees for that, and that could be a consideration. Similar possibility to incorporate by reference. Not all offices allow incorporation by reference. I haven't explained this too much, this concept, but it's basically the possibility if your PCT application is incomplete or maybe contains the wrong set of claims, that you have the opportunity to pull what's missing or what should have been included from the priority application into the PCT. So if it's been correct in the priority application, you can possibly still save the content of your PCT application through incorporation by reference. Not all offices accept that, so maybe you want to start filing as a safeguard your PCT applications always with an office that accepts incorporation by reference. Acceptance of pre-conversion files. This is important for electronic filing. We always recommend, if at all possible, to attach a copy of your original document, which is often a Word document, before you converted it into a format for filing. And the formats for filing are generally PDF and XML. So add those Word files as well, because if you can show afterwards that there was a conversion error, then you are allowed to go back to your Word document. So that's a good safeguard as well. Not all offices accept pre-conversion files, even though most offices now do, but there might also be a consideration in terms of choice of receiving office. I think these considerations are probably more special kind of situations, and I think most applicants will still be driven by convenience and which office they're most familiar with. So I did already talk about competent receiving office. And again, it's really mostly dependent on the, competent searching authority. It's dependent on who you choose as a receiving office. And all offices have selected who they would like to work together with. So with some ROs, you have a large choice. With other receiving offices, the choice is relatively narrow, like the EPO, just one office, for instance. It's a little bit special if you file with the receiving office of the International Bureau. We don't actually have a list of offices that we would like to work together with, or we haven't also been able to select all 25. The rules basically provide that we need to look at who are the applicants and determine if they hadn't filed with us, with which other receiving office could they have filed their PCT application. And then we turn to those potential receiving offices, and based on the choice of those receiving offices, those choices then also apply with filings with our receiving office. Sounds complicated, but if you take an example, like you have an application where you have a Japanese applicant, you have a US applicant, and you have a European applicant, and that application is filed with the ROIB, with our receiving office, then we look at Japan, Europe, and maybe also the national office of wherever that European applicant is from, the US, Japanese, and Europe. Yes, okay. And we turn to those offices and we check which offices would be competent ISAs if you had filed with any of them. And then it's this combination of all those offices that become available to choose from when you file this particular application with the International Bureau. Okay, and of course that choice, if you do have a choice, needs to be indicated also in the request form. All right, and before I end my presentation part and open the floor to Q&As, so you might as well start to get ready if you have any questions to start typing them in. If you haven't done so already, I just wanted to show you this slide here to give you really a good overview over the whole PCT procedure. And I covered some of these aspects already, especially those at the very beginning on the left side of the slide. So most of our applicants file with a first national or sometimes regional, like an EPO application, and that takes you to 0 month, which is then your priority date eventually. And then they follow it up with a PCT application before the expiration of 12 months, and of course claiming priority of that first national application. There are also applicants who file right away a PCT application, and those applicants are applicants who are maybe not so worried about the patent term. Patent term is once you get a patent granted to you, how long you can maintain this patent. And some applicants are very interested in a long patent term. The maximum is 20 years generally around the world. And they're interested in a long patent term because their inventions are particularly valuable towards the end of the patent term. I'm thinking of pharmaceutical companies and inventions in that field. They really like a long patent term. And if you like a long patent term, you try to max it out by first filing a national application and then only a PCT, because then the patent term for all countries other than where you filed your initial application will only start to run from the PCT filing date. And so they just like to have a little extra time, if at all possible. So first national application generally, then PCT, then the receiving office gets a hold of your application and will determine whether they can give an international filing date to your international application. They will then do also a formality check on your application and will see whether you have complied with all the formality requirements of the PCT. If they find you haven't, then they will issue an invitation to you and invite you to fix. And it's a good idea to actually correct these defects, because as I said at the outset, if you do comply with the PCT requirements, then later on in the national phase, no office can challenge you and ask you for compliance with different requirements. So it's really a good idea to kind of bring your PCT application, formally speaking, in order before you eventually then enter the national phase. The receiving office will also send a copy of the application, the search copy, incidentally, to the searching authority so that they can start with the international search and eventually produce a search report and a written opinion, which is a non-binding opinion on whether your invention is novel, inventive, and industrial applicable. The search report will also cite all relevant prior art that they find and will categorize the prior art in which sense that prior art is relevant. So for instance, is it a document that destroys novelty? That would be indicated in the search report, and it also will indicate for which claims such a document is relevant. Once you receive the search report, you have a 2-month window to file Article 19 amendments. Those are amendments to your claims, and these amended claims will be published at 18 months or promptly after 18 months by the International Bureau together with the claims as originally filed. After that, you have 2 optional procedures. Just to highlight here, you can file what's called a demand for international preliminary examination that would eventually get you what's called an IPRP Chapter 2, an international report on patentability, Chapter 2. And that is an opportunity for an applicant to, on the one hand, file further sets of amendments, not only of the claims as under Article 19, but also amendments to the description, to the drawings, and to enter into a discussion with the examiner with the aim to possibly obtain a more positive result than what was obtained in the search report and written opinion. The second optional procedure is called supplementary international search, which will lead to a supplementary international search report. That is basically an opportunity on the same application to get a second search report done by a different searching authority. So in this case, you're not able to amend your application, so it's not going to be possible to file amendments and then get a search report by a second authority on the amended application, but it will be on the application as originally filed, but from a different searching authority, with the idea that this authority might have access to maybe some prior art in languages not so accessible to the main searching authority, and will possibly then find certain relevant prior art documents and make them known to you before you decide to enter the national phase. And that takes me to the last part really of this overview of the PCT timeline, and that is entry into the national phase. So at 30 months, that's unfortunately when you really need to now take the hard decision where you would like to continue with your application, before which offices, and then do what we call enter the national phase. And so with this, I have run a little longer than I had originally expected. There are just a few slides here at the end on our website where some of the things that I talked about, like the applicant's guide, our list of contracting states, can be found. And our last slide, if it does want to come up, it doesn't seem so. All right, is about how to reach out to us, how to ask us more questions. We have a standing line, the PCT info line, where you can ask any kind of questions relating to a PCT, or if you're already filing PCT applications, if you have certain questions about a particular application that you have submitted, you can always reach out to us. And at this point, I will stop sharing, which will hopefully allow me to see the Q&A a little bit better. And I'm trying to make that, oh, that's a little too big now. Okay. So I am just going to go through the questions as I see them on my screen, and I will read them out to you so that you hear them. So the first question is, can Indonesian applicants file directly to IB? Yes, in principle. Indonesia has been a member state of the PCT for many years, so they are clearly entitled, first of all, to file a PCT application, and they could select the receiving office of the International Bureau as their receiving office. But again, you would have to be cautious in the sense that if there are provisions of national law that require you to first file locally so with the Indonesian authorities, you should first do that. Now, I must admit offhand, I would have to now also turn to the PCT applicants guide that has this information in it. I'm not quite sure what the requirements of Indonesia are in this respect, but some requirements can also be complied with by already having filed your first application in Indonesia. And if you're not changing your application, then under the law of many countries, it is assumed that if an office hasn't objected that you continue with this application, you can then also file it as a further application in other countries. But really, you should carefully check what the requirements are of each and every office. But short of that, and apart from that, yes, applicants from Indonesia could file directly with the International Bureau. As the PCT extends to so many states, why an applicant from other countries cannot apply directly for a PCT? Wouldn't this opening help incentive non-contracting states to join the PCT? Let me see whether I fully understand this. Yeah, I think if I understood the question correctly, so it's down to the question, why aren't we opening up the PCT to just any applicants? And that's actually what national law does. I mean, a US application, anyone can file a US application, so it's not restricted to certain nationals or residents. I think originally why this was put like this into the PCT was really to get countries to join the PCT. And by having such a requirement to create an incentive, if you join the PCT, then your nationals are entitled to benefit from the PCT. Now, of course, we've come a long way from that, but unfortunately, that requirement has been hard drafted into the PCT treaty. And anything that's in the PCT treaty is very, very difficult to change. It would require a diplomatic conference, and this is not easily doable. So as a result, we're a bit stuck with this requirement. Okay, is Arbua mentioned? I have no idea what we're talking about here. So I'm gonna pass on that question. I'm very sorry. I'm not sure what this is supposed to mean. Which office permits extension of the 18 months limit? So I'm guessing this relates, I mean, this must be someone who's really been following the PCT for many years, because basically today all offices apply the 30 months time limit. So they all extend after, the end of 12 months for another 18 months to enter the national phase. There's basically only one office, gosh, if I'm not mistaken, is it one or two at the moment, that strictly speaking would still have a requirement that you enter the national phase at 20 months. And these offices simply haven't changed their national law, even though the PCT was changed in this regard back in 2003. Those offices, however, are also covered by a regional arrangement. So the way around this, if you really want protection in one of those offices, would be to simply go ahead and file for a regional or to enter the regional phase, either before the EPO or before a REPO. And basically that way still benefit from the additional 18 months that you refer to in this question. So in practice, it's not really an issue. And one could say that basically, if you want protection in any of the PCT contracting states, you'll get there either through direct national phase entry before most offices, or by entering the regional phase before a regional office. But so really worrying about the 20 month is not really worth the trouble anymore. To confirm, is it okay to file a Word version of the patent application as well as a PDF version of the application? Correct. Yes. So this is what I refer to as the pre-conversion file, the Word version of the patent application. And so it depends a little bit on the receiving office. One of the receiving office that does not accept for you to file the Word version as a safeguard is the USPTO. That's the one office I know off the top of my head that does not allow this. But Our office, RIB, accepts it. EPO and many other offices do accept it, and it's the safeguard that if you had drafted your application in Word, you then converted it into PDF, but let's say a chemical formula was wrongly converted, and instead of alpha says A or something like that, then you could go back to the Word document even after publication and still get that conversion error fixed in your PCT. And so in principle, many offices do accept that you also file the Word version, but not unfortunately all receiving office. And this again is information that's contained in the applicant's guide. And so you could find out whether your receiving office of choice does accept to include the Word version. And if it does, I would absolutely recommend that you always include also the Word version. And you don't have to worry about visibility of that Word document to third parties. It's an internally handled document that's not going to be put on patent scope. So third parties cannot see the Word file of your application that you're submitting just as a safeguard. So if a person submitted individually, can they have a lawyer deal with submissions if there was a challenge on claims? So that's actually probably a question relating to whether you need to have a lawyer. Well, we generally in the PCT refer to him as an agent, whether you need to have an agent represent you to file a PCT application, or whether you have the choice of hiring an agent and let him or her do the work for you in either filing or dealing with subsequent documents. Most receiving offices do not have a requirement that you need to appoint an agent, but our recommendation often is, unless you're very familiar with the PCT, that it probably makes sense to hire the services of an agent. And I think it actually, usually starts even before the filing of the PCT. You probably want to have someone who really knows about the drafting of patent applications to draft a good patent application for you. And so you need a lawyer probably already for that. Maybe you want to use that lawyer to file the national application, and you want to maybe use the same lawyer then to file a PCT application. So unless you're very familiar with the processes and you're comfortable in handling all of this, and you're also willing to take the risk that if you miss a time limit, it's on you and not on the person you hire to do it for you, then in these cases, of course, you could, in many instances, also do it yourself. And if you initially thought, I can handle this, and then you get some communications that you're not so certain about, sure, at this point, you can also turn around and say, well, now I feel safer hiring a patent attorney or patent agent to continue help me with the application. So this can also be done subsequently. So if the first filed application is a PCT, would there be a 12 months due date to file any non-PCT countries claiming priority to the PCT application? Example, can you file an application in Argentina within 12 months of filing date of the PCT application? Is that possible? Yes. So you can file first a PCT application and either follow it up within 12 months with a second PCT application. That's also done sometimes by some applicants. Or instead of filing a second PCT application, you can also just use the PCT as your priority date and follow it up within 12 months with further direct national applications. And of course, that really only makes sense for non-PCT contracting states, but it would require that wherever you're filing your subsequent application applies the right to claim priority under Article 4 of the Paris Convention. Now, Argentina is part of the Paris Convention, so for Argentina, it would work, but, and this is going to strain myself quite a bit because I can't really think off the top of my head of a good example of, a state or an entity that's not part of Paris end of PCT, there it would be difficult to follow it up within 12 months and claim priority of the PCT. Now, interestingly enough, it would also work in the case of the territory of Taiwan. Taiwan, even though not recognized as a state, cannot be part of the Paris Convention either, but they are a member of WTO. In the TRIPS agreement of the member states of WTO, they have basically incorporated Article 4 also into the TRIPS agreement. And so basically Taiwan accepts the fact that you filed in another either Paris or TRIPS country before, and then you can follow that up within 12 months with a further application in Taiwan. So in many instances, it will work, but in practice, it's more rare, and it's probably not the standard thing for applicants to do, but it is possible. So there's a question whether we will also be organizing a webinar on filing of a European patent applications. No, unfortunately, and I hate to say no, but I don't think we will do that because we don't want to step on the toes of our dear colleagues at the European Patent Office. They will do hopefully such things, and they also organizing courses either in person or online on the filing of European patent applications. So we don't think it's really up to us to offer that. During the PCT, when you can select the countries where the international application will enter the national phase at the latest. So yes. So if I didn't make that clear, so you file your national application at the end of 12 months, you file your PCT, then you have 18 additional months, or if you count 18 plus 12, it's the famous 30 months that I always talked about. So 30 months from your very first filing to take the ultimate decision where you would like to enter the national phase. And of course, that decision shouldn't be taken on the last day, but ideally a little bit earlier. But that's the maximum that's guaranteed to you. Having said that, there are some offices which give you even more time. Many of you might know the European Patent Office actually gives you 31 months to enter the national phase. I think by now also the Korean office offers 31 months. Some offices, I think, even offer 32 months. So there are some possible extensions, but what's legally assured to all PCT applicants is that you have at least 30 months to take that decision where you would like to continue. Some countries benefit from reduced fees for PCT application. In the case of two applicants, both must be from a country that benefits this discounted fees in order for the application to benefit. Yes, so there are discounts for nationals and residents of certain countries. And if you want to claim this benefit, all of your applicants need to benefit from this discount. They must be nationals and residents of particular contracting states in order for this to work. Is the national phase entry equivalent to getting a domestic patent? That sounds like a simple question, but it's actually probably more complex than that. So national phase entry basically means that you take your PCT and you ask one of the designated offices that's designated in your PCT to continue processing that application. So in a way, it's not a new application, but it's the same PCT application that is now being picked up by one of the national offices or regional offices as a designated office to further process it and eventually grant a patent. So in comparison to a direct national application, it's actually already the filing date of the PCT application that should be compared with the direct national application. So the filing of the PCT is actually already like trying to obtain a domestic patent if you so wish. But procedurally, really, it's only starting to happen once an office is allowed to touch this PCT application. And unless an applicant asks for early processing, national offices cannot really start processing a PCT application before the expiration of 30 months. So in a way, the 30 months work to the benefit of the applicant in the sense he or she has 30 months time to decide where they want to continue, but it also keeps designated offices from already picking up that application and working on it and deciding whether a patent or not can be granted, because they have to wait until the expiration of 30 months. I hope that makes some sense. Under the PCT, what is the significance of the domicile residency requirement for applicants, and how does it affect the ability to individual or legal entities to file international patent applications? Additionally, how is domicile determined when there are multiple applicants from different countries? Yeah, so I guess I went into this point before, so it's probably something that was included at the start of the PCT back in 1970 when this was all discussed, that it was supposed to be an incentive to have this requirement so that more and more countries would actually end up joining the PCT. So what it means in practice is a receiving office will look at who are the applicants on a PCT application, if there's more than one, and they will then have to determine, is at least one of the applicant either a national or a resident of a state that's a member state of the PCT. So that's really all that is required. So if you have one that is and the other one that isn't, or you only have one that's a national but not also a resident, that would be perfectly enough for the office to accept this application as a PCT application and to give it an international filing date. So really, if you have multiple, essentially, it doesn't matter so much. I mean, for statistical purposes, it might matter, like, do we consider an application to be filed by someone from, I don't know, Canada, or someone from Venezuela is maybe not the best example because they're not a contracting state, or from Jamaica. So there we usually take the first applicant and his or her national residence. But in order to get a filing date, it doesn't matter whether the fifth applicant is entitled to file. That would still be good enough to get a filing date. Okay, isn't there a chance that filing amendments to the application will result in a more restrictive protection than what a single state could oppose to in a later particular national phase? Wouldn't it be convenient to amend the application when requested in those part and limit to what the specific state needs to do? Yeah, that's a very good point. Thanks for raising this. I did mention Article 19, Article 34 amendments as a possibility for applicants. It's not a must. No one needs to file Article 19 amendments or Article 34 amendments. As a matter of fact, very few applicants actually do, and they do exactly what I think you are hinting at. That is, they wait until national phase entry. So they enter the national phase before a particular office, and they wait then for a national office action to tell them, hey, we can't grant a patent unless you amend certain claims in your application. And only at that point will they react, and they will only then maybe modify their applications, amend their applications to the extent as required by that particular national office. And that allows you to really kind of fine-tune your application depending on each jurisdiction where you're entering the national phase, and to only limit it as much as need be in a particular jurisdiction. If you do it during the international phase, you're right, there is a risk that you might restrict it more than you absolutely have to, than in a particular country. So that's why a lot of applicants do not amend during the international phase, but they wait until national phase entry. Okay, so it was Aruba, and I'm still not sure I know whether Aruba is actually part of the PCT off the top of my head. It's not something that comes up so often. So I'm sorry, I have to take a pass on this one here. I don't want to say something that's not correct. So if you're interested in who is part of the PCT, really go to our website and check all of our contracting states. Sometimes things are a little bit complicated when we're talking not about some entity recognized as a state, but some dependent territories, and then you would need to check whether whoever that country is dependent or that territory is dependent on, whether the protecting country, so to speak, has extended the PCT to that country. So that's really only relevant if an entity is not recognized as a state. So you would have to carefully check in these cases. If an applicant misses the 1 year period after first national filing, file a PCT, what can he do to recover the right to file? Yeah, so I haven't really entered into this because this is a little more of a complex topic. But in this case, the choice of safeguard that you have is to request restoration of the priority right. So this is something that was introduced not that long ago, but probably by now it's 10 years. And it allows, in certain cases, to ask the receiving office to still accept a priority claim, even though it was outside, the PCT was filed outside of the 1 year period. Now, there's a limit to this. You can only file your PCT later by 2 months. If you're even more late than 2 months, it's not going to be possible to request restoration. So the window really is 2 months, and it's also within these 2 months that you need to file the request to restore your priority right. It's not a simple, I would like it, please give it. You actually have to explain why you missed the priority period. And depending on the receiving office, they either apply a standard called unintentional or due care in spite of the circumstances. And unintentional might be easy to comply with by simply saying, sorry, I forgot. But due care really requires a more careful explanation why, even though you are a careful applicant or agent, you did not meet the 12-month period to file the PCT application. If you don't do it with the receiving office, maybe because your receiving office doesn't accept requests for restoration, you can still request restoration of the priority right also when you enter the national phase before designated offices that do apply this safeguard. No, so WIPO is WIPO enforcing common application format for the PCT. Other countries will have to accept CAF. No, no, we're not. I mean, we have, so to speak, the own PCT standard for what's required in terms of the formatting and all of that. So we're not as such applying the common application format. If we don't get a domestic patent, can we apply for a global patent in other countries? So careful with the term global patent. So there's no such thing as a global patent. There is an international patent application, which is the PCT, but the PCT is never turning into a patent. With the PCT, you need to eventually enter the national phase and ask one of the designated offices to continue processing your PCT in the national phase. And it's then ultimately a national or maybe sometimes a regional patent that will be granted, but never a global patent. So the fact, however, that your home office maybe didn't grant you a patent doesn't necessarily mean that other offices won't grant a patent on a particular invention. So it is, of course, possible to try with other offices, but it will largely also depend on the reasons why the domestic patent wasn't granted, whether you still have a reasonable chance to obtain patents in other jurisdictions. But please don't think of a global patent, because this doesn't really exist. Can I share equity or royalties from my patent as fees with patent agents and lawyers? That's a contractual question that you need to discuss with your agent and lawyers, and whether that is actually permissible in a particular country. It's really a question of national law, and the PCT doesn't regulate this. But you can always ask an agent or an attorney if that's something that would potentially be acceptable, but it's really dependent on the particular country you're talking about. Will your next webinar take participants into the ePCT and go through the process? Yes, we will have one particular session dedicated to ePCT. I think that's episode 4. So will tease you still with some other stuff in episode 3. I think we're going to talk in more details about time limits, how to calculate time limits in the PCT. That's foreseen for the next episode, and then the one after will be on ePCT. If I make a mistake in my PCT application, for example, in the drawings, when and how can I correct? So if you make a mistake in your drawings, it depends a little bit on what kind of mistake you're talking about. There is a standard mistake that is you drafted maybe your drawings, you sketched it by hand, you submitted that. That's considered often as an informal drawing. And if you then would like to submit a formal drawing with, done with a good instrument, et cetera, that's doable, subject to invitation, or even without ever getting invited by the receiving office. Within 2 months from the invitation, or within 2 months from filing, and that time limit can even be further extended close to international publication. So these kind of formality defects in drawings are easily correctable, and that's really not a big issue. If your mistake in the drawings, however, is that you didn't properly disclose a feature of your invention, then things become more difficult. If you're then submitting a replacement drawing that shows more details than was originally contained, the receiving office usually would not accept that and would invite you to submit this question to the ISA. Why to the ISA? Because the staff at the ISA are substantive examiners, and they can look at the substance of applications. Whereas at the receiving office, it's not necessarily that there's anyone who has a substantive understanding of your application. So if there is a potential change in the contents due to your later submitted drawings, then you probably would need to get this authorized by the ISA. And in this case, it would be under the standard of Rule 91, rectification of an obvious mistake. And it really would have to be something that's obvious, that you really meant it differently. If it's more in the sense of an amendment, then it probably will not be accepted at this stage, but you can try to submit it as an amendment later on. But again, there you might face the difficulty that a lot of under the PCT, but also under national law, the requirement essentially is that you cannot add new subject matter once you file your application. So that's the one part where you have to be really careful. So are 1D, 2D drawings safe for patent applications? At the moment, clearly 3D is not safe. I'm not actually 100% sure what 1D and 2D really stands for. I have to actually think about this. So our standard for drawings really is that it has to be basically done in black and white. I suppose for me that's 1D, or maybe that's 2D. And that is acceptable as a drawing, but anything fancier like 3D or color or video and etc. is unfortunately not yet acceptable. Oh, and I got a helpful colleague who reminded me that Aruba is part of the Kingdom of the Netherlands. Okay, so I think Aruba actually might be considered part of the Kingdom of the Netherlands, and therefore the PCT also extends to Aruba. But again, I would recommend do double check with the PCT applicant's guide whether this is really the correct information. I'm reading this a little too quickly now because we're over time. We're supposed to end our webinar. So I think that was the last question and last point I wanted to make. So at this stage, I really just wanted to thank everyone for your interest in the second episode, and do join us for the third episode, which I don't want to make a promise when that will be, but it will be announced on our website, and you will then hopefully have a chance to also join us at that point. So thank you very much and enjoy the rest of your day. Thank you.